Chair, we're live.
Good morning. It's 9 o'clock. We call this meeting to order. If we can have a calling the roll of the commission.
Great, thank you, Chair. Member Jerry Merritt.
I'm present.
Great. Member Dennis Nylander.
Present.
Member Durrett.
Here.
Member Young.
Present.
And Chairman Douglas.
Good morning.
Great. Deputy Bala, can you please confirm that we have complied with the open meeting law requirements?
We have, sir.
Great, thank you. Well, Chair, with your approval, I will get started by introducing agenda item 1. Great. Agenda item number 1 is public comment. Ms. Bonner will now read into the record all public comment received up until the start time of the meeting. Any public comment received after the start of the meeting will be read into the record at the second public comment period. Ms. Bonner will end each individual reading at the 3-minute mark, and all public comment will be posted online for the public to view immediately following the meeting. So with that, Ms. Bonner, please proceed.
Dr. Clemens, we have 4 public comments that we received before the meeting. The first one is from Andrew George. I'm a shareholder in Ianthus Capital Holdings, and I would like to submit my following comments, complaints in the next public meeting. I understand the NCCB has received 2 complaints about the conduct of Ianthus trading as Green Mart of Nevada NLV LLC, complaining that Ianthus lied to the NCCB about who the Green Mart CEO was, had lied to their shareholders in the market about their financials on the same day that they issued an opposing financial statement to the NCCB, that the CEO had been fired after he received undisclosed interest-free loans from the main principal of their senior lender, GGP, and yet the NCCB has settled with Ianthus and approved GGP as the new controlling shareholder, and has only responded to the 2 complaints that an investigation into Ianthus/Green Mart would be quote-unquote inappropriate. If licensees are able to issue false statements to the regulators, the market, the shareholders, and receive quote-unquote undisclosed loans, under what circumstances would the NCCB act to policy the licenses that they issue? Now, both Anna McMahon and Timothy Pong submitted the same public comment, and it reads as follows. I understand the NCCB has received 2 complaints about the conduct of Ianthus trading as Green Mart of Nevada NLV LLC. Ianthus lied to the NCCB about who the Green Mart CEO was, and they lied to their shareholders in the market about their financials on the same day that they issued opposing financial statements to the NCCB. The former CEO had been fired after he received undisclosed interest-free loans from the main principal of their senior lender, GGP, who is set to gain the most after the recapitalization and wipe out shareholder value. How are licensees able to issue false statements to the regulators, the market, shareholders, and receive undisclosed loans and be granted a license transferred to their ownership? What would the NCCB do to policy the licenses that they issue? The NCCB has settled with Ianthus and approved GGP as the new controlling shareholder, and has only responded to the 2 complaints that an investigation into Ianthus and Green Mart would be inappropriate. Please don't let them get away with stealing this company. And the last public comment we received prior to the meeting is from Hardy Borden. I'm a shareholder with Ianthus and have been one since 2017. I have a significant position in Ianthus as an active shareholder in this company concerned with the conduct of Ianthus trading as Green Mart of Nevada NLV LLC. And I'd like to register a complaint about the conduct of Ianthus. The deception and manipulation within the Ianthus executive and lenders is astounding and cannot go unnoticed and dealt with. Ianthus lied to the NCCB about who the Green Mart CEO was, and they lied to their shareholders in the market about their financials on the same day they issued opposing financial statements to the NCCB. The former CEO, Hadley Ford, had been fired after he received undisclosed interest-free loans from Jason Adler, the founder and main principal at GGP, the senior lender for Ianthus. GGP was set to gain the most after recapitalization while essentially wiping out the shareholders. How are license transfers able to be granted to those that issue false statements to regulators, the market, shareholders, and receive undisclosed loans? This is just wrong. The unfortunate result of not correcting these deliberate situations where obvious deception and manipulation has occurred is the corruption and injustice continue to prevail. Allowing this to happen further erodes the confidence of the markets and in the long run destroys it. It's wrong. I understand that the NCCB has settled with Ianthus and approved GGP as the new controlling shareholder and has only responded to 2 complaints that investigation into Ianthus and Greenmark will be quote unquote inappropriate. What is inappropriate is not investigating when issues such as these come up. We're expecting that the argument of public policy exception applies such that a U.S. bankruptcy court should refuse to recognize the foreign reorganization of a cannabis business as, quote, manifestly contrary to the public policy of the United States. Ianthus has defaulted against the lenders for not making interest payments on April 6, 2020. The lenders are attempting to find a loophole in the system by using Chapter 15 to conduct a plan of arrangement and restructure an insolvency bankruptcy matter. So it's permitted under Chapter 15. It does not explicitly permit insolvency or bankruptcy matters involving cannabis, which is illegal on the federal level. However, this is an issue that has to be clarified and determined prior to any transfer of ownership or accepting a variance request. Investigation and refusal is requested. Time is of the essence, and I would appreciate a response ASAP. And with that, Director Klimas, I'll turn it over back to you.
Thank you for that. Moving on to agenda item number 2, this is the approval of minutes. Chair?
We have the minutes provided to us. Hopefully the commission has reviewed them. If we can get a motion for approval.
Member Durrett, for the record, I move to approve the April 27 minutes.
We have a motion for approval. Do we have a second?
This is Jerry, I second.
Okay. Any additions, corrections, or comments? Hearing none, all in favor accepting of the minutes, please say aye.
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 Aye. Any opposed? Any abstentions? Matter's been passed. Takes us to item number 3.
Chair, item number 3 is to consider the proposed settlement agreement in the case of Compassionate Team of Las Vegas, LLC versus State of Nevada Department of Taxation. I will now turn it over to CCB Counsel, Senior Deputy Attorney General Ashley Balducci, to present this item to the board.
Good morning, Chair and members of the board. For the record, I am Senior Deputy Attorney General Ashley Balducci. Item 3 on the agenda is a proposed settlement agreement to resolve litigation with Compassionate Team of Las Vegas, LLC, and process its transfer of interest request. The litigation at issue involves a unique set of facts that does not set any sort of precedence for the CCD. Unless there are any questions regarding the proposed settlement agreement, I request approval of the proposed settlement agreement. I believe opposing counsel is attempting to participate in the Zoom meeting right now. He may be having some technical difficulties, but I believe he's attempting to at this time.
With that, do we have our licensee, Mr. Simon?
Amber, please unmute Mr. Simon. Mr. Simon, if you are on, please announce yourself.
This is Amber Bergler, for the record. I don't see anyone with that name that has joined.
Okay, what I'm going to do is ask
Or
to
a phone
hold,
number.
this item. We'll trail it because we would like to have the licensee on the record as to this proposed settlement, even though he's signed the documents, if at all
Excuse
possible.
me, I see that he has joined.
Mr. Simon, have you joined? Mr. Simon, have you joined? Can you hear us?
For the record, Ashley Balducci, I believe he's muted.
Okay, I got it now.
Good morning, sir.
Good morning.
We have a matter on for consideration of a settlement agreement that the parties have signed. And for the record, Mr. Simon, you are the licensee, and you've entered into this negotiated settlement that would grant the license you're asking for as well as a transfer of interest. Is that correct, sir?
That's correct.
And you are familiar with the terms and conditions of the settlement and you agree with those terms and conditions?
I do.
Okay. With that, unless you have any other comment, if we can get a motion for approval of this settlement agreement that's been provided to the commission?
Chairman, if you're ready for a motion, I'm prepared to make one.
Please go ahead.
In respect of the matter number 3 on our agenda today, the proposed settlement agreement and request for transfer of interest regarding Compassion Team of Las Vegas, I would move for approval.
A motion for approval. Do we have a second?
Member
This
Drat,
is,
second.
It's been moved and seconded. Any additional discussion as to this item? Hearing none. All in favor of approval of the settlement agreement that would grant the license and the transfer of interest, please say aye.
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 Aye. Any opposition? Any abstentions? Matter carries. Mr. Simon, thank you very much for your cooperation and consideration in this matter.
Thank you,
And thanks,
Justice Douglas.
staff.
Great. Move on to agenda item number 4, Chair, members of the board. This is the consideration of proposed settlement agreements to resolve disciplinary action. Senior Deputy Attorney General Chris Rath, also counsel for the CCB, will present on the 2 proposed settlement agreements for the board to consider individually. With that, Deputy Rath.
Thank you, Executive Director Klimas. Chair, members of the board, good morning. L. Christopher Rath, Senior Deputy Attorney General. We have 2 settlement agreements up for approval on this agenda item number 4. As per usual, I will provide you with a brief summary and the Attorney General's recommendation for approval. You may then ask me any questions, and the licensees and their counsel are also present, and you may ask them any questions and then decide on which action to be taken. So with that, I'll start with the first case, which is Cannabis Compliance Board versus Sean Cheraki, CCB case number 2020-09. This complaint was filed and served on August 25th, 2020. The respondent answered the complaint on October 2, 2020. CCB then assigned a hearing officer and the matter proceeded into administrative disciplinary process. During the course of the disciplinary process, counsel for Mr. Cheraki and the Attorney General's office, in consultation with CCB staff, undertook extensive settlement negotiations and came to a mutually agreeable proposal for resolution of this matter, which is embodied in the settlement agreement before you. The events at issue in the complaint occurred at a cultivation facility in March 2019 under the Department of Taxation. The allegations in the complaint involved misrepresentations regarding use of certain equipment and obtaining required permits for equipment. The complaint alleged that these misrepresentations were intentional or, in the alternative, unintentional. There was a companion complaint filed separately against the facility where this occurred and where Mr. Cheraki works, alleging similar violations and several others against the facility. That companion matter was resolved and the board approved that as settlement agreement back in January of this year. As set forth in this settlement agreement, proposed settlement agreement, to resolve this matter, the respondent admitted to 2 Category 2 violations for unintentionally concealing evidence. Respondent also agreed to the imposition of a civil penalty in the amount of $100,000. Finally, respondent also agreed that his agent's cards are to be suspended for 35 days. If this settlement is approved, that suspension would commence tomorrow morning. Respondent has provided a plan of correction, which is summarized in paragraph 20 of the settlement agreement, and the CCB staff has approved this. This plan of correction lines up with the plan of correction his facility has already undertaken and will help both of them to ensure they remain transparent and open with CCB staff going forward, and issues like this do not reoccur in the future. Accordingly, the Attorney General recommends and requests the CCB approve the settlement agreement. I am available for any questions, as is respondent and his counsel.
With that, Mr. Cracky, are you available?
Amber, if you could please unmute Crane Pomerantz and Sean Shiraki. Mr. Shiraki, are you on the line?
Good morning, Your Honor, and Director Cannabis. This is Crane Pomerantz on behalf of Mr. Shiraki. He's present with me.
Good morning. This is Chair Douglas. We have an agreement before us as a settlement item that outlines a fine in the amount of $100,000, a period of suspension, and a plan of correction. And I have a signed agreement, but for the record, does Mr. Karanki understand that? And does he agree to those particular specific terms?
He does, Your Honor. We've reviewed the settlement agreement with him, which was the product of strenuous negotiations with the Deputy Attorney General. Mr. Shiraki is contrite. He apologizes, but we would urge you to follow the recommendation in the agreement between the parties.
Just for the record, Mr. Shiraki, you've heard your counsel. Do you agree with the statements that he's just made?
Good morning, Your Honor. I do agree with the statement my attorney just made.
Thank you, sir. Members of the board, do you have any additional questions as to our counsel or to counsel for Mr. Shiraki as to this matter?
Mr. Chairman, this is Member Nylander. Maybe this is for our executive director, but if I could just get an update on the correction plan and how that's going from either our side or the licensee's side.
Thank you, Member Nylander. I would ask Counsel Chris Rath if he has an update on the plan of correction.
Thank you, Director Klimas. As the correction plan was outlined originally in the complaint against the facility has updated its employment manual to require the staff to be truthful and transparent with CCB staff and other regulatory agencies. They've also updated their standard operating procedures on remediation device to ensure the proper approvals from CCB. Mr. Shiraki has affirmed that he has read these updates and that he will comply with them. Mr. Pomerantz can give us any further updates he feels are needed, but that's generally where we stand.
Great, thank you very much.
Any other questions or concerns by any of the commissioners? If there's no other corrections or concerns, if we can get a motion for approval, if that's appropriate at this time.
Mr. Chairman, this is Member Nylander. I would move for approval of agenda item number 4A, CCB versus Sean Shiraki, as stated on the agenda.
Thank you. Can we get a second, please?
This is Member Young. I'll second that.
We have a second from Dr. Young. With that, we have a motion, a second. All in favor of the settlement agreement, please say aye.
Aye.
Aye. Any nays? Any abstentions? Motion carries. Thank you very much. Thank you to the council. Mr. Shiraki, Mr. Shiraki, please abide by the settlement agreement and go forward. Thank you.
Thank you, Your Honor, and to members of the board. Thank you.
That moves us to item B, Curaleaf Holding. Mr. Rath.
Thank you, Chair. The next matter is Cannabis Compliance Board versus Curaleaf Holdings LLC, case number 2021-38. This case did not involve a complaint. Rather, as you recall, at the last CCB meeting in April, the CCB considered requests for transfers of interest by Curaleaf. After the discussion, the CCB requested CCB staff and the Attorney General's office consult with respondents and their counsel to see if an acceptable settlement agreement could be reached to address the areas of concern CCB had expressed with respect to the TOI requests. After the April meeting, Curaleaf's counsel held extensive discussions with both myself and Mr. Staley, and we came to a mutually agreeable resolution that was agreeable to Respondents Council, CCB staff, and the Attorney General's office. Curaleaf is the parent company for a number of licensees, and the transfers of interest affected a number of licensees and certificate. The respondent licensees are each listed in the settlement agreement. The settlement agreement lists each licensee as well as the license and certificate numbers for each. Thus, the 5 respondents are 1, Acres Cultivation LLC, 2, Acres Dispensary LLC, 3, Acres Medical LLC, 4, Las Vegas Natural Caregivers LLC, and finally 5, Matrix 2 LLC. As indicated in the settlement agreement, respondents waived their rights to the filing and service of a disciplinary complaint and admitted to the imposition of 1 Category 2 violation for failing to notify the Department of Taxation of a change in ownership interest. Respondents also agreed to pay $35,000 as a civil penalty. CCB staff agrees that this violation and penalty appropriately addresses their areas of concern and that the licensees have been fully advised about and understand the requirements and procedures for obtaining approval of transfers of interests moving forward. As a result, the Attorney General recommends and requests the CCB approve this settlement agreement. I'm available for any questions, as is counsel for respondents.
Any questions of our counsel at this time? We will move to our licensee and counsel.
Ms. Verkler, if you could unmute Amanda Connor and Peter Clateman, please. And Amanda and Peter, when you are unmuted, you may go ahead and announce yourself.
Good morning. This is Amanda Connor on behalf of the licensees. And I believe Peter Clateman, General Counsel for Curaleaf, is also joining.
Yes, hello.
Good morning. This is Chair Douglas. For the record, we have a settlement agreement before us. It resolves the issue as to the transfer of interest concern that the board had represented. With that, any representations, and are you in agreement with the settlement agreement and the proposed fine?
Yes.
All right.
Yes, we are.
Thank you. We understand there was some difficulty in this over time, but it's now been taken care of and resolved. We thank you for your cooperation. With that, if we can have a motion, unless there are any questions from any of the board members.
Rihanna Durrett, for the record, I move to approve the agenda item 4B, the settlement agreement between Cannabis Compliance Board and Curaleaf Holdings.
We have a motion for approval of the settlement agreement with Curaleaf. Do we have a second?
This is Member Young. I will second that.
We have a motion. We have a second from Dr. Young. With that, any additional questions? Hearing none, all in favor, please say aye.
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 Aye. Anyone oppose? Any abstentions? That motion carries. We thank counsel and the licensee for their cooperation.
Thank you, Chairman and the board.
Great. Well, that takes us, Chair, to agenda item number 5. This is the request for transfers of interest. Dave Staley, Chief Investigator for the CCB, will now present on this item. Chief Staley, when you're ready.
Good morning, Chair Douglas, Member Merritt, Member Nylander, Member Durrett, and Member Young. For the record, I am David Staley, Chief Investigator for the CCB. Can you hear me okay?
Yes, we can.
Okay. I'm here to present agenda item number 5, which consists of 3 transfer of interest or TOI applications. Item A is the TOI application for Helping Hands Wellness Center, Inc., or Helping Hands. TOI number 21050 requests approval for Frank and Florence Jameson to purchase 70% interest in Helping Hands from Clarice Tertarian and Luzine Denayan Tatarian and Denayan will remain involved with Helping Hands through their respective remaining 15.75 and 14.25% ownership. Staff identified no areas of concern with this application. I'm available for any questions, and my understanding is that Jared Kahn and Dr. Florence Jameson are present today via Zoom to address any questions you may have as well. With that, Chair Douglas, I'll turn this item back to you.
Thank you. Members of the commission, any questions of Mr. Staley as to this matter? Hearing none, if we can have our licensee and counsel.
Amber, if you could unmute Dr. Khan and Ms. Florence Jameson. And Dr. Khan and Ms. Jameson, if you are unmuted, please announce yourself.
Florence Jameson.
Hi, Jared Kahn, counsel for the entities.
Good morning.
And Florence Jameson. And thank you very much to the board and the Honorable Chair, Michael Douglas, for putting us on the agenda today. Thank you.
Thank you. Good morning. Members of the board, we welcome the licensee and counsel. Any questions of licensee or counsel as to this? There were no area of concerns listed, but if there's any questions, it's our opportunity to ask those.
Mr. Chairman, this is Member Nylander. I don't have a question. I just wanted to relay to the licensees that, you know, a lot of our agendas have been filled with, you know, resolving previous matters where the things weren't done correctly. And in this instance, the licensee, there are no areas of concern, and just to commend them on their ability to follow the rules and to submit a clean application. It's nice to see.
Thank you for that comment. With that, if we have no questions, if we can get a motion for approval of our transfer of interest as to Helping Hands Wellness Center.
Mr. Chairman, this is Member Nylander. I would move for approval of transfer of interest item 5A as stated on the agenda, and I don't believe we have any additional conditions.
And with that,
This is Jerry Merritt. I second the motion.
it's been moved in second. Any additional discussions? With that then, if all in favor, please say aye.
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 Any opposed? Any abstentions? Motion carries as transfer of interest as to 5A, Helping Hands Wellness Center. Thank you.
Thank you.
Thank you very much. And we just wanted to make sure we say thank you to the commission, the staff, Mr. Staley and Ashley Liano for all their diligence and efforts. Thank you very much.
Thank you.
I'd just like to echo that. Thank you so much. It was an absolute pleasure working with the staff, Ashley, Dave, and I can't thank you enough, our medical director, and I'm sorry, director, and I'm in medicine, I apologize, and chair, thank you again.
Thank you and good luck. With that, Mr. Staley, we move to CW Nevada.
Thank you, Chair Douglas. For the record, I'm David Staley, Chief Investigator for the CCB. Item B are TOI applications for CW Nevada LLC or CW, Desert Evolution LLC or Desert Evolution, BDLV Investment Holdings or BDLV, and James Hammer. TOIs number 21-00006, 00007, and 00008 request approval for the sale of CW cultivation, production, and dispensary licenses in Clark County to Desert Evolution, BDLV, and Hammer. CW experienced solvency issues during late 2018, and since cannabis is still illegal at the federal level, CW could not take advantage of federal bankruptcy protection. As a result, CW filed an application to appoint receiver with the 8th Judicial District Court in Clark County, or the court, on February 27th of 2019. The proposed sale of CW licenses to Desert Evolution, BDLV, and Hammer were facilitated by the court-appointed receiver. In addition, Desert Evolution and BDLV have requested waivers pursuant to NCCR 5.112 and 5.125 of the requirements of NCCR 5.110 regarding a review of all owners. Desert Evolution and BDLV have adequately addressed the items required in NCCR 5.112 and 5.125 to allow the board to approve such waivers. Staff suggests that if approved, the board limit Desert Evolution and BDLV's 5.112 and 5.125 waivers to expire on such agenda date as Desert Evolution and BDLV's next TOI applications are heard. Staff identified no areas of concern with this application. I am available for any questions, and my understanding is that Dotan Melek, John Savage, Jeff Donato, Sheba Statham, Melissa Waite, James Hammer, and Rob Singerland are present today via Zoom to address any questions you may have as well. With that, Chair Douglas, I'll turn this item back to you.
Before we go to the licensee, members of the commission, any questions of the investigator, Mr. Staley?
Mr. Chairman, this is Member Nylander. Mr. Staley, do we still have additional applications pending for CW Nevada?
Yes, Mr. Member Nylander, the court-appointed receiver sold or went into sales agreements for both the CW Nevada assets before you today and also some assets in Nye County. That application was filed and staff is currently working on that investigation. We don't have an agenda date yet. We are tentatively hoping for the June agenda on that item.
Okay, thanks for that update. I appreciate it.
Any additional questions? I would note for the record, we did receive correspondence from a former owner, Mr. Pageant, still contesting the action. However, that matter is being handled in district court and they've approved this matter. Just so stating for the record. With that, if we can have the licensee and counsel, if we have counsel.
So great. So Amber, if you could unmute we have quite a large contingent from CW Nevada here. So if you could unmute those individuals, that'd be great. And whoever would like to jump in and announce yourself, that would be great. Thank you.
Good morning, Director Cannabis, Chairman Douglas, members of the board. My name is John Savage. I represent Dotan Melek, the receiver over CW Nevada.
And this is Jeff Donato of Argentum with compliance on behalf of the receiver.
Good morning, Director Cannabis, Chairman, and honorable board members. This is Dotan Melek, receiver.
Good morning to the parties. This matter seems to be in order based upon review by our licensing investigator. And with that, unless you have statements you wish to make to us as to this matter, I have no questions, but that does not mean board members do not have questions. Any questions or that any board member wishes to present as to this matter? Right then, with that, if we can get a motion for the acceptance of this transfer of interest, noting the waiver condition.
Mr. Chairman, this is Member Nylander. I would go ahead and move for approval of agenda item number 5B, CW Nevada, and the 3 sub-items underneath it as stated on the agenda. And I believe we do have one condition that we need to attach that Desert Evolution LLC and BDLV Investment Holdings waivers pursuant to NCCR 5.112 and 5.125 are limited to expire on such agenda as Desert Evolution LLC and BDLV Investment Holdings next TOI application is heard.
Thank you. We have a motion. Do we have a second?
Member Durrett, I second.
We have a motion. We now have a second. Do we have any additional questions or any concerns? Hearing none, all in favor of this transfer of interest as to item 5B, 1, 2, and 3 sub. All in favor, please say aye.
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 Aye. Any opposed? Any abstentions? This motion carries. Thank our licensees and the other parties, council, for their actions as to this particular matter. Motion's been moved and passed.
Thank you.
We now turn our attention to item C, Mr. Staley.
Thank you, Chair Douglas. David Staley, Chief Investigator for the CCB for the record. Item C are the TOI applications for Digipath Inc. or Digipath. TOIs number 17013A and 17013B were filed by Digipath requesting approval to issue shares of stock to Joseph Bianco and Todd Denkin, then approval for the sale of Bianco's shares after his death. In addition, Digipath has requested waivers pursuant to NCCR 5.112 and 5.125 of the requirements of NCCR 5.110 regarding the review of all owners. The company has adequately addressed the items required in NCCR 5.112 and 5.125 to allow the board to approve such waivers. Staff suggests that if approved, the board limit Digipath's 5.112 and 5.125 waivers to expire on such agenda date as Digipath's next TOI application is heard. Staff identified areas of concern with TOIs number 17013A and 17013B because Digipath completed the requested transfer prior to board approvals. In addition, Digipath completed the issuance of securities to various of its officers and directors between 2016 and 2020 without filing TOI applications or prior board approvals. Specifically, Digipath and CCB are agreeable to a settlement agreement on the following terms: an admission to 1 Category 2 violation for failing to report a transfer of interest, and 2 Category 4 violations for failure to have owners, officers, or board members with valid agent cards, with a total civil penalty of $20,000 to be paid in 4 installments. If the board is agreeable to this approach, a formal stipulation for settlement will be prepared for approval at a later board meeting. I am available for any questions, and my understanding is that Todd Peterson, Todd Denkin, Bruce Rabin, Neil Tomlinson, and Christina Kleiss are present today via Zoom to address any questions you may have as well. With that, Chair Douglas, I'll turn this item back to you.
Thank you. Members of our board, any questions that you would have of Mr. Staley before we hear from the licensing council? With that, if we can hear from licensee and council.
Ms. Verkler, if you could unmute the individuals here representing Digipath and representatives. When you're unmuted, if you could please announce yourself. Thank you.
Good morning, Chair Douglas and members of the board. This is Neil Tomlinson from the Brownstein Hyatt Law Firm. We're here representing Digipath Inc. and Digipath Labs today. Thank you.
Morning.
Hi there, Todd Denkin is here on the line too.
Good morning.
Bruce Rabin from Digipath on the line, gentlemen.
Morning. Representations that on behalf of the licensees to be made?
Yes, Thank you, Chair Douglas. Again, Neil Tomlinson on behalf of the licensee. We agree with what Chief Staley put on the record. We appreciate their professionalism. We've worked with them long and hard on this matter to make sure that we can clean up and correct the transfers of interest that were of concern. And we appreciate also the Attorney General's office, and especially Mr. Rath, for his professionalism as well. So thank you very much.
And you've heard, again, just for the record, you've heard the representations of, as to this matter and a proposed resolution of this matter. Are you in accord with that?
Yes, Chair Douglas, we are. Thank you.
All right. In this matter, unless there's any additional comments or questions, if we can get a conditional approval subject to the resolution being memorialized in this matter. And I don't, Mr. Staley, if you can repeat, or Mr. Rath, the necessary conditions for the record so that it's memorialized.
Yes, Chair. This is Christopher Rath, Senior Deputy Attorney General. The basic terms of the settlement agreement would be in addition to 1 Category 2 for failure to report a transfer of interest to the department, 2 Category 4 violations for failure to have officers or directors holding agent cards, and a total civil penalty of $20,000. If that is approved, we will draft up a settlement agreement for your final review at the next meeting.
With that, can we have a motion for the conditional approval, subject to this matter coming back to us next month for a final approval based upon a fully executed settlement agreement?
Mr. Chairman, this is Member Nylander. I would move with respect to agenda item 5C, DigiPath Inc., that we conditionally approve the transfer of interest subject to the parties coming to a appropriate settlement agreement to appear on the next month's agenda. And I would note that it appears the parties have already done that, but in following with our prior practice, I would move for the approval to be conditional. And in addition, the approval would also be a second condition that the waivers of NCCR 5110 pursuant to NCCR 5112 and 5125 are conditioned to expire on such agenda date as DigiPath's next TOI application is heard.
We have a motion for conditional approval and waiver of certain conditions. With that, do we have a second?
This is Member Young. I will second that.
Thank you, Dr. Young. We have a motion, we have a second. Any additional questions? Hearing none. Can we have a motion for the conditional approval and waiver at this time? All in favor, please say aye.
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 Aye. Any opposed? Any abstentions? That passes. Hopefully the parties can get together and we will have this timely on our next agenda for final approval, but it's conditionally approved at this time. Thank you very much for the cooperation.
Thank you guys very much.
Thank you, Chair Douglas, members of the board.
Thank you, staff and member in AG office.
Great. Chair, we'll move on to agenda item number 6. This is to consider the approval of management services agreements. Management service agreements, excuse me. We have 2 for the board to consider today. Chief Staley will also present each of these items for the board consideration. Chief Staley, when you're ready.
Chair Douglas, members of the board, for the record, I'm David Staley, Chief Investigator for the CCB. I'm here to present agenda item number 6, which consists of requests for approvals of various management agreements. Item number 6A is a dispensary management agreement between DE Dispensary Ops NV LLC and H&H Management LLC. DE Dispensary Ops NV LLC is the dispensary subsidiary created by the sale of CW Nevada's dispensary license to Desert Evolution LLC, BDLV, and James Hammer. H&H Management LLC is owned by James M. Hammer, James Hammer's son. CCB staff have reviewed the agreement and found it appropriate. I am available for any questions, and my understanding is that Melissa Waite, James Hammer, and Rob Slingerland are present today via Zoom to address any questions you may have as well. With that, Chair Douglas, I'll turn this item back to you.
I have a question just off the top. In this management agreement, it's for a 5-year with 2 options thereafter for 2 additional 5-year periods. I'm just a little bit concerned in terms of approving the management agreement with the 2 additional 5 years without this coming back to the board at the end of the first 5-year period to see what's happening with this particular management agreement. That's my only concern. It just may be me, but I like to put better eyes on these kinds of things when we have someone managing property. And I don't know if this is a normal situation or not from your standpoint, Mr. Staley.
Chair Douglas, Chief Staley for the record. I don't know that we've reviewed enough management contracts yet to really get a feel for what's normal and customary. A 5-year with potential 5-year renewals, I don't believe are unusual from my general experience, and the owner of the management company is related to the owners of the entity. We can address any concerns that you may have, however you feel is appropriate. I am, however, comfortable and have no real concerns about the additional 5-year extensions.
Thank you. At this time, any other questions, Mr. Staley, from board members? If not, can we have our licensee and counsel?
Great, Ms. Verkel, if you could unmute. It looks like they are all together in Las Vegas down there. And then Ms. Wade, Mr. Hammer, Mr. Slingerland, if you could announce yourself.
Thank you, Amber. Can you hear me okay?
Yes, we can.
Great. Melissa Waite with Dickinson Wright for the record. Good morning, Chair Douglas, Executive Director Klimas, and members of the board. We were not able to appear on the prior item for CW, but we appreciate your approval for that item. I think we weren't quite able to jump in off mute, but with regard to this item, I'm here representing Desert Evolution and its subsidiaries. With me this morning, I have Rob Slingerland. He's the CEO of Desert Evolution and its subsidiaries. And I also have James Hammer. He's an owner and member of the Board of Managers of DE Dispensary Ops. And we would just like to thank everyone for their assistance, their professionalism, particularly Chief Staley and Jane Maurer, who assisted us in investigations for both of these items. And if there's no questions for the applicant, we would like to request approval of this item.
Members of the board, any questions or that you wish to ask the applicants or counsel?
Yes, Mr. Chairman, this is Member Nylander. I think this is for Ms. White. Based on your experience, are these types of built-in extensions common in management agreements for this industry?
Yes, we have seen that pretty much across the board. There are circumstances where the parties are getting comfortable with the relationship where you might see a shorter term to start, maybe a 1-year term or a 2-year term. But with this situation where H&H has previously been approved as a management company, has been operating at this location and doing a very good job with no issues, the parties opted to go for the longer term. I think if there were a situation where the board wanted to request that we come back at the end of the term prior to a renewal, we would be amenable to that. But happy to, come before you again if you think it's appropriate at the end of that initial term.
Well, yeah, and the reason I asked the question is that this is a little bit unique in as much as there is almost a related party transaction. So these are, essentially family members. I'm sure the Hammers are tired of getting the jokes about hammer time. So I won't tell the hammer time. So Mr. Chairman, I'm comfortable given the circumstance of this one, but if it would be appropriate in your view, I'd be amenable also to going down a path and just to see what the other board members think of a condition that not that the renewal has to come back in front of us necessarily, but it would be subject to submission and administrative approval by the CCB staff through the executive director. If there is a concern, I'm just thinking of ways to approach these to give us the right amount of coverage.
Any other member of the commission wish to voice approval or reservation or concern?
Member Durrett, for the record, I'd be supportive of that approach.
Okay. Anyone else wish to? Okay. Then based upon that, it seems that, I too would like to see a little hands-on at this point since it's kind of a new thing for us. And I'm very agreeable to having any subsequent approval or review left in the hands of our director and CCB staff. And we should only see this if there's a problem. Having said that, if someone feels they can make a motion for that acceptance.
Mr. Chairman, this is Member Nylander. I'll try to put the hammer down on this one. So I would move for approval of agenda item number 6A, H&H Management and DE Dispensary as reflected on the agenda, and that approval would be limited to expire. Well, actually, I won't limit the approval. The approval will be conditioned that within 30 days of the expiration of the first tranche, as stated in the agreement, that the licensee shall request administrative approval in order for the second tranche to kick in. And that would not come before the board unless the executive director had raised some issues. And actually, I'd like to amend my motion to make it 60 days prior to. I think that would give everyone a little more time and just a comment that it's not a reflection on this licensee at all. It's just, as the chair said, this is a new area for us and probably want to make sure we're using belt and suspenders approach as we get comfortable.
With that belt and suspenders approach, do we have a second to Mr. Nylander's amended, his own amendments to his motion for approval?
Member Durrett, a second.
A motion, we have a second. Any questions or clarifications? Any board members? If not, all in approval, please say aye.
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 Aye. Any opposed? Any abstentions? Matter carries. We thank the licensee and hopefully everything will work out and go forward with this venture and the family will still be intact in 5 years. With that, if we can move our agenda to DB Labs.
Thank you, Chair Douglas. Chief Investigator Staley for the record. Item number 6B is a management services agreement between DB Labs LLC and Keisha IP LLC. CCB staff have reviewed the agreement and found it appropriate. I am available for any questions, and my understanding is that Alicia Ashcraft and Susan Bunce are present today via Zoom to address any questions you may have as well. With that, Chair Douglas, I'll turn this item back to you.
Any questions of Mr. Staley before we turn it over to council and the party? With that, if we can unmute.
Ms. Merkel, if you could unmute Ms. Ashcraft and Ms. Bunce, please. And Ms. Ashcraft, when you're unmuted, if you could announce yourself.
Thanks so much, Director Klimas, Chair Douglas, members of the board. Alicia Ashcraft of the law firm of Armstrong Teasdale. On behalf of the manager under this agreement, Keisha Group and Keisha IP, with me today is also CEO James Horvath. We're available to answer any questions the board may have, and we appreciate the board's consideration of this item. Thank you.
Thank you. Anyone have any questions at this time?
Mr. Chairman, this is Member Nylander. Just maybe this is for, I don't know if it's for Ms. Ashcraft or Mr. Staley, but what is the expiration on this one? I'm trying to find the term. I had it earlier. I can't find it now. I apologize.
Page 6, 10 years from the effective date.
Member Nylander, this is Chief Investigator Staley. My understanding is that this management agreement was put in place with the anticipation that Keisha has submitted a TOI application for the potential acquisition of DB Labs. I don't anticipate that our review will take 10 years. So I believe that that's just built into the management agreement because they needed a term. But both Keisha and DB Labs have filed a TOI application with the CCB, and it will be investigated by staff and presented to you when we're done with that background investigation.
Oh, that makes sense. Thank you for that. And I think you you said hopefully it won't take you 10 years. I think you gave Mr. Klimas a heart attack. 10 years to do a simple TOI, that would be a problem. But I don't have any questions or concerns, Mr. Chairman.
All right, if there's no questions or concerns, I have one additional comment, but I will hold that at this point. With that, if we can have a motion for approval.
Mr. Chairman, with respect to agenda item 6B, DB Labs and Keisha, I would move for approval.
Do we have a second?
This is Jerry. I second.
We have a motion for approval and we have a second. All in favor, please say aye.
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 Any opposed? Any abstentions? Mr. Staley, I would just ask on this one, if for some reason as you're investigating on this one, because we have a 10-year with the possible renewal for another 10, if there's something that goes awry in terms of the TOI going forward in the future, that you report that back to the director so we can put fresh eyes on this to be consistent with what we did on the previous matter.
Yes, sir, Chair Douglas.
That moves us to item 7, consideration of approval of a retail license agreement.
Thank you, Chair. So correct, agenda item number 7, and this will also be presented by Chief Staley. So Chief Staley, when you're ready.
Chair Douglas, members of the board, for the record, I'm Chief Staley, David Staley, Chief Investigator for the CCB. I'm here to present agenda item number 7, which consists of request for approval of a licensing agreement. Item number 7A is a retail license agreement between Integral Associates LLC and Cookies Creative Consulting and Promotions LLC. Staff have reviewed the agreement and found it to be appropriate. I am available for any questions, and my understanding is that Amanda Connor is present today via Zoom to address any questions you may have as well. With that, Chair Douglas, I'll turn this item back to you.
Okay, members of our board, do you have any questions as to this approval? Which is a very interesting item and with branding and all this other, but having said that, any questions? Then if we can have Ms. Connor and licensee.
Ms. Barker, could you please unmute Ms. Connor? And I think we have Ms. Mahone as well from Integral Association Cookies Creative. And please go ahead when you're unmuted. Ms. Connor, are you on? Can you hear us?
Good morning, Amanda Connor on behalf of Integral Associates. I believe Ms. Mahone on behalf of GTI or Integral Associates had to step away, but I am available to answer any questions you may have. We kindly request that the board approve this licensing and branding agreement.
Hello, this is Ms. Mahone. I'm here as well.
Good morning.
Good morning.
Board members, any questions?
No, I don't have any questions. It's just interesting. I've seen these kind of promotional agreements in other industries, but I don't know that we've had one like this in front of us yet. I don't have any concerns or questions though.
I likewise have no concerns. It is interesting. It's for us, it's a new plateau. Wish the licensee success with this. Any other board members have questions? It's on for possible action. Mr. Staley, do we have anything that we need to attach to this, or are we just good with a standard motion for approval?
Chair Douglas, Chief Staley for the record, I believe we're ready for a standard approval.
With that, if we can have a motion.
Member Durrett, for the record, I move to approve agenda item 7A, the licensing agreement between Integral Associates and Cookies Creative Consulting.
We have a motion for approval. Do we have a second?
Member Merritt, I second.
Motion, we have a second. Any additional discussion or questions? Hearing none, all in favor, please say aye.
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 Any opposed? Any abstentions? Motion carries. Thank you very much.
Thank you, Chairman and members of the board.
Thank you.
Great, Chair. Moving on to agenda item number 8. This is a status update in consideration by the board of possible action regarding the petition filed by Crooked Wine pursuant to NCCR 13.025. Deputy Director Michael Miles is on, and he'll go ahead and present this item and introduce a representative from Blackbird to address the board. Deputy Miles.
Good morning, Chair and board members. Again, I'm Michael Miles, Deputy Director of the Cannabis Compliance Board. First, as an informational item, in February, Blackbird Logistics submitted an NCCR 4.45 petition requesting a change to the cross-docking regulation. We have taken informal comments on this requested amendment, and a workshop will be scheduled in June after session's over to work out a potential change to NCCR 13.020. Also, Blackbird Logistics had previously submitted an NCCR 4.45 petition requesting a change to the two-driver rule under NCCR 13.025 subsection 5 to a single driver. The board has granted emergency relief due to COVID-19 and has waived the two-driver requirement for a limited time. They're requesting an additional extension and for the board to make the emergency relief permanent. Presently on Zoom is a representative of Blackbird Logistics, and they are available to briefly summarize their position at the board's request and answer any questions the board may have. CCB staff is also available to answer any additional questions from the board. With that, Chair, I turn it back to you.
Thank you. With that, if we can have representative from Blackbird Logistics, Crooked Wine.
Ms. Verkel, if you could unmute Jennifer Gallerini, Ms. Gallerini from Blackbird. And when you're ready, if you'd like to give the board an update on on where we're at, that would be great.
Good morning. Thank you, Director, Deputy Director, Chair, and members of CCB. My name is Jennifer Gallerani. I'm the Vice President of Logistics for Blackbird Logistics. And as Deputy Director, Mr. Miles just summarized, this is a petition on the 2-driver rule, which we submitted back in December of 2020. I'd like to start off by saying thank you again for your continued extension of this waiver. It has proven to be extremely successful in keeping our workforce safe during the COVID pandemic. Because we were allowed to just have a single driver in our closed cargo vans for the duration of the pandemic so far, we have had 0 instances of work-related COVID cases in our deliveries. We would like to continue to request that extension at this time. Approximately 50% of our drivers are fully vaccinated, which means they're still waiting for their second booster shot, essentially, or their first. But with that continued extension, again, for the next 90 days, that will ensure that our drivers are safe, especially as retailers and dispensaries start lifting their COVID requirement, their mask mandates and things like that. We want to make sure that our drivers who are not fully vaccinated continue to be protected in every way possible. Again, the existing regulation as written in section 13025, section 5, does require a second driver for any delivery of wholesale value exceeding $25,000. At this point, being active in the market for as long as we have, that equates to approximately 80 to 85% of our wholesale deliveries. So nearly all of our deliveries require a second driver if this regulation is maintained in place. For the duration of the time that we have had a single driver, in addition to being very successful in the COVID case and keeping our workforce safe, we have had 0 instance in terms of security. There has been no instances of concern in terms of robberies, targeted or otherwise. We also have the support of the Dispensary Association. If you refer back to our original petition, we lay out the requirements for security when we're loading and unloading, that being in secure areas, under camera, with very clear SOPs for both pickups and drop-offs. And the dispensaries are on board. Everyone feels that a single driver is adequate. And we would like to again petition that in addition to extending it during the COVID pandemic as we near the end of this, to sincerely consider repealing the requirement for 2 drivers in perpetuity. And with that, I'll answer any questions that anyone may have.
Thank you. Questions by board members? Hearing no questions. Thank you. I will speak for myself at this time. I would like to see us continue this exemption under COVID. We're still kind of in a strange gray area of whether, with things opening back up and counties and whatnot taking control, and pretty much we're 50, 60 different percentages around the state. But I'd like to see us have this back on, continue it for 30 days at a minimum to our next meeting, the exemption, to get a report from the workshop that's going to be held next month to give us some idea what's the appropriate action of whether the recommendation or the feeling will be to change the rule or to continue the rule or to modify the rule. I don't know, and if so, what type of timeline would we need to take formal action to see if another extension would be appropriate? But that's kind of where I'm at least allow 30 days to get a better feel from the workshop of what's going on, and then take the action necessary to reinstate or repeal or to modify the existing rule. Other feelings or concerns?
Mr. Chairman, this is Member Nylander. I agree with you. I think that we'll know more after the workshop is completed. But I also am mindful that if we do either amend the regulation or repeal it, that process, and maybe this is for the Attorney General's office, but we've got to give notice. It's got to go through LCB on some level. It's got to be approved by the governor's folks. And so there is a time, there's some time built into there if we do something. But like you said, I'm not sure what we're going to do. So I was going to say a longer period of time, but maybe we just do 30 days and revisit it and see what happens.
Anyone else wish to express? That being the case, I would make a motion to continue our exemption for an additional 30 days, to have this back on our agenda for the next meeting, to take whatever action is appropriate following the workshop.
I would second that motion.
It's been moved and seconded. Any additional discussion? All in favor, please say aye.
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 Anyone wish to oppose that motion? And any abstentions? Matter carries. We'll continue with the present exemption for additional 30 days at this time. We'll be back on our next meeting.
Thank you.
Thank you.
Thank you, Chair. Moving on to agenda item number 9. This is an informational item presented as a notice to the board of establishments that have been issued their final license since the last board meeting. So with that, I will ask Steve Gilbert, Head of Licensing, to please present on the notice this month. Mr. Gilbert.
Morning, Chair, members of the board, Steve Gilbert for the record. Agenda item 9A is an informational item presented as a notice to the board of establishments that have been issued their final license since the last board meeting. We have one license to note today. On December 5th, 2018, Nevada Organic Remedies, LLC, RD 217, was issued a conditional license for an adult use retail store in the city of North Las Vegas. On April 22nd, 2021, the Cannabis Compliance Board conducted a pre-opening inspection and audited the facility located at 420 East Deer Springs Way, Suite 100. The inspection and audit results revealed the facility was in compliance with NCCR and Title 56 of NRS. A statement of no deficiency was issued on April 27th, 2021. And as a result, the CCB approved and issued a final license to Nevada Organic Remedies, LLC, RD 217 on May 7th, 2021. With that, Chair, members of the board, I'm happy to answer any questions.
Any questions by any of the board members? Hearing none? Thank you very much.
Right. All right, Chair, moving on to agenda item number 10. This is the briefing from myself. Chair, members of the board, for my report this month, I'll provide you with a brief update on the legislative session, followed by some additional items of note. We're now 7 days away from the end of legislative session. There's still some significant policy measures that are making their way through the legislature. We continue to be engaged and track on these bills, and we'll certainly plan to update the board following the end of the session on Monday. The CCB's bill, Senate Bill 49, will be voted on by the Senate sometime this week. If approved, it will then head to the governor's desk for signature. Other items to note, as you know, this board met telephonically last week to consider the suspension of a cultivation license due to a public health and safety threat. The board voted to suspend the license, and our agents proceeded with successfully facilitating the suspension on site. The licensee has 10 days from that date to respond with a plan of correction, which will be reviewed and come back in front of this board for approval. I also wanted to provide an update on agent cards today. The CCB continues to receive around 60 agent card applications per day. that number has remained fairly consistent even through the pandemic. Staff is processing anywhere from 60 to 100 temporary agent card letters a day. There is no backlog of applications. Outside of weekends, we begin to process submissions on the day they are received, and significant work has been done by our licensing and agent card team to bring us to where we're at today. Payments on agent cards still need to be mailed in by check or money order, so processing time for a new applicant to receive a temporary agent card, as long as the application is filled out correctly and all information required has been submitted, is tracking at around 14-day turnaround. Again, important to note, the temporary card is all that is required for an applicant to begin working in the industry. The hard card comes later after an applicant passes his or her background check. Now, the time it takes to receive that hard card is wholly dependent upon the time it takes for the FBI and the Department of Public Safety to process the background check and return the results to the CCB. Right now, that's taking it around 45 days. We're continuing to work on rolling out ACH or electronic check payments that we hope will provide additional opportunities to speed up the processing time. However, until we see action at the federal level on increased banking opportunities, online payment options will remain limited. I did mention at the beginning of the year, we'd be launching a small pilot program to allow for licensees to establish a revolving account with the CCB. This account would be used by licensees to authorize immediate drawdowns to pay for sponsored agent cards, thus eliminating the mail-in payment processing times. We had 2 licensees establish an account, and through the hard work of our CCB fiscal and licensing teams, the program has been a success. Given this and the opportunity for some additional resources and staffing from the legislative session, we will look to roll this program out to any licensee in the coming fiscal year. Once this program's up and running, it'll also allow for other billings like time and effort to be drawn out, thus further reducing the administrative burden on both the industry and the CCB. Next, more of note to the industry, we had an issue recently with what amounted to a landlord and tenant dispute over rent. Obviously, when issues like this arise under normal circumstances in other industries, there are certain actions like locking a tenant out that can be taken in certain circumstances. Obviously, with cannabis, you may only take possession of cannabis if you are licensed to do so. The CCB has a role to play in these kinds of disputes, but only to ensure the safe removal, transfer, or destruction of product. That liability and responsibility is also on the licensee, no matter what dispute is ongoing. These kinds of issues should also likely be addressed in lease agreements to prevent any confusion in an event of a dispute or any other issues that may come up. If there are questions as to a situation, I encourage licensees to reach out to our licensing division to ensure you're operating in compliance of the NCCRs. So finally, some quick housekeeping, Chair. The next board meeting, will likely be in person. We are still waiting on guidance from Buildings and Grounds as to exactly what that will look like and if there will be any limitations, but we will try to bring clarity to that as soon as we can. Also, as Deputy Director Miles mentioned, we are planning on having our workshop or our next workshop in mid-June. That will likely be open to the public as well in some form. That notice should go out in the next week or so. This workshop will discuss and address many of the regulations that were sent out for informal comment most recently. So with that, Chair, members of the board, that concludes my remarks for today. Happy to answer any questions.
Board members, any questions, Mr. Klimas? Hearing no questions, you're letting him off light today. As was indicated, our next meeting is set for June 22nd, and notice will go out to how that public meeting will be conducted, either in person or one more month on Zoom, hopefully in person. With that, again, as always, if we have items for future agendas, please provide us with the necessary information. And if we can have public comment, if any.
Thank you, Chair. We did not receive any public comment through the meeting, so we can move on to the next agenda item.
With that, can we have a motion for adjournment?
Mr. Chairman, I would move for adjournment only on the condition that we need to get you a gavel. This isn't right. You need a gavel, Mr. Chairman.
I had a gavel for 25 years and never used it. With that, we are adjourned. And we can't give you any more vacations, Mr. Nylander.
Understood.